Morning, Your Honors. The matter before the court today is the case entitled State of Vermont versus Randall Swartz, case number 23 AP 393. Representing the appellant, Randall Swartz, is Sarah Starr. Representing the appellee, State of Vermont, is Evan Meenan.
Okay, thank you very much, and good morning, counsel. We'll hear from appellant. Please introduce yourself and your client and then proceed.
Good morning, Your Honors. I'm Sarah Starr, and I represent the appellant, Randall Swartz.
Thank you.
Mr. Schwartz's counsel plea bargained for the dismissal of the first-degree murder charge against his client and for an open sentencing on the second-degree murder charge. Defense counsel did not and could not have silently plea bargained away Mr. Schwartz's rights under the Fifth and Sixth Amendments as articulated in United States versus Apprendi. This is because those rights were never explained or even mentioned to Mr. Swartz by the trial court anywhere in this record. So appellant never agreed or understood that the court would apply a presumptive sentence, but yet the court stated multiple times that that was what it was doing. And so the court applied what it repeatedly called the presumptive sentence and then made findings to justify deviating upwards from the presumptive sentence. And those additional facts and that additional fact finding constituted a clear constitutional violation that requires resentencing in this case.
So Ms. Starr, can you help me understand how Apprendi applies? Because the court did not apply the statutory maximum here.
It didn't apply the maximum, but it applied a presumption, which is a determinate sentence. And so it was operating, I mean, Vermont has an indeterminate sentencing scheme, and it enacted that to comply with Apprendi. But what the court did was applied a determinate scheme. And the Supreme Court's jurisprudence under Apprendi has really just reinforced that those determinate sentencing schemes that require additional fact finding, there's a right to a jury trial on those additional facts. And so there was no warning, there was no explanation that he had such a right, and there was really no warning that the court was going to revert to the abrogated and repealed sentencing scheme rather than Vermont law, which is indeterminate.
Ms. Starr, is there anything unlawful about the sentence that was imposed by the trial court?
So it was unlawful in that it was the result of unconstitutional fact finding. Also, the fact
it was within statutory. It was within what the statute says is can be a maximum minimum on this offense. It
was within that, yes, but it was far outside of what similar. I mean, we have here an extremely impaired defendant with like astronomically high blood alcohol content who ended up being sentenced based not on the facts, but on a presumption to a sentence that was a far outlier for similar offenses in Vermont. So here's somebody who was at a 0.301 blood alcohol content, who is basically going to be serving the rest of his life in jail when what he pled to was a second degree, and he was sentenced as if this was a premeditated murder. And so I think that makes it an unlawful sentence. And if there's no questions, I'll reserve the rest of my time.
Thanks very much. We'll turn to the appellee. Please, counsel, introduce yourself and your client and then proceed.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont, which in this case is asking the court to affirm appellant's sentence of 30 years to life for murdering his wife, Thea Swartz. In this case, and contrary to appellant's arguments, the court did not impermissibly apply a presumptive minimum sentence or apply the sentencing scheme that was in place prior to this court's decision in Provost and Act 119 from 2005. Appellant's arguments to the contrary make an erroneous assumption, and that is that they conflate applying or considering aggravating and mitigating factors when deciding what sentence to impose within a statutorily authorized range, which is entirely permissible, with the court finding aggravating or mitigating factors to actually increase what the otherwise legislatively established minimum and maximum sentences are. That would have been impermissible, but that's not what the court did in this particular case. And its sentencing decision was consistent with Apprendi, Provost, and Act 119. The court's reference to a, quote, presumptive sentence referred to the mandatory minimum sentence in Section 2303A2.
The 20-year sentence, Mr. Meenan, that's the 20, I mean, the statutory minimum's 20 and the maximum life.
That's correct. That's correct, Your Honor. And the court's reference to a, quote, upward expansion of that minimum simply recognized that in Vermont's indeterminate sentencing scheme, judges have the authority to apply a sentence that's higher than that 20-year minimum. And in fact, in, I believe it was the Provost case, this court noted that in response to the United States Supreme Court's decision in Apprendi, the legislature could have done a couple of things to amend Vermont's homicide statute, one of which was to permit, quote, an indeterminate sentencing scheme placing greater discretion in trial judges. The second option would have been a scheme requiring judges to conduct whatever additional fact-finding was necessary to expand the maximum potential penalty that was imposed. In Act 119, the legislature chose the first option, which essentially rendered sentencing for second-degree murder cases operates the same exact way as sentencing for most other offenses in Vermont, except for the fact that there is the 20-year minimum. And as a result, what the court did when it determined the intent with which appellant acted, the court didn't increase what the maximum potential penalty was, because as Your Honors recognized, the sentence that the court imposed was entirely within the parameters of 2303. In other words, when the court found that appellant intentionally killed his wife, it didn't determine that he acted with any mens rea other than one of the mens rea that can support a conviction for second-degree murder. So the court's determination didn't do anything to affect the maximum potential penalty that appellant faced. Instead, it just considered the nature and the circumstances of the offense, which includes the intent with which appellant acted, and determined that based on the nature and circumstances of that offense, a minimum sentence that was higher than the 20-year minimum sentence was appropriate.
How should the court factor in the alcohol consumption?
The court did factor in the alcohol.
No, how should they? I mean, what's the proper method of trying to do that, or is it just discretionary with the trial court?
Well, I think that the court is required to consider mitigating factors that appellant can proffer forward. I mean, appellants during sentencing proceedings have the right to offer mitigating factors in pursuit of a plea of leniency. But then once we're operating within the indeterminate sentencing scheme established by 119, the court's consideration of mitigating factors falls within its general sentencing discretion. And whether or not somebody else who also has committed a second-degree murder received a lesser sentence is not dispositive in this particular case. This court has recognized over and over again that sentencing statistics and sentencing decisions in other cases have limited import. What really is important is, did the court consider the traditional sentencing factors? Did the court consider the statutory sentencing factors? And in doing so, did it exercise its discretion to reach an appropriate sentence?
Thanks. Your time has expired.
Thank you.
Thank you very much. How much time does the appellant have, please?
Appellant has 1 minute, 8 seconds remaining.
Counsel?
Thank you. To say that all that the court did in this case was to apply the mandatory minimum ignores what the court said 3 separate times it was doing, which was applying a presumptive minimum. And that is the key difference here, where the court didn't say it one time and then referred to the mandatory minimum, or the other times. The court said it repeatedly at different stages, including when it was announcing the sentence. And so if Mr. Swartz had known that there was going to be a presumption applied based on mens rea, I think there's a strong likelihood that he would have wanted a jury to determine that, especially given the very persuasive and strong evidence of his impairment. And so because he was not warned of that, he really would not have gone to this type of sentencing based when there was, if the court was going to be applying a presumption, which really took off the table what the defendant was asking for, which was a lower sentence than what the court called the presumption. So the case should be sent back for resentencing for those reasons.